but I think it's just we're going to have to settle with early rather than bright looking out the window. But just a few housekeeping points. I notice you all do have your microphones on mute, but if you could just keep them on mute during the session, it's entirely up to you whether you want to keep your camera on or not. Please note that nothing contained in this session is legal advice. So if you need legal advice relating to specific circumstances, you can ask a barrister directly if the matter is non-contentious, which is, in other words, not in relation to anticipated litigation. If the matter is contentious, you must go to a solicitor who will then instruct a barrister. Having said that, there will be a Q&A session at the end for general questions, which I will do my best to answer. Anything that I'm not able to answer immediately, I will think about and get back to you. But again, with the caveat that I cannot give legal advice on specific situations within the context of this session. And then most importantly, there will be a break at around 9:45, so circa 45 minutes, for 15 minutes to let everybody grab a tea or a coffee. So let us make a start. So I think in order to understand copyright and understand where it's coming from and the reason for its existence, it's important to have an understanding of the history of copyright. Ireland has, as far as I know, one of the earliest, or if not the first recorded instance of a copyright enforcement action, which dates back to the 6th century, where King Diarmid ruled in a dispute between St. Columba and St. Finian. In this case, Columba had borrowed a Psalter from Finian and secretly copied it in order to have a copy to study at his leisure. Diarmid famously stated, ruling in Finian's favour, that to every cow belongs its calf, to every book its copy. Which in other words means that each copy of a book belongs to the owner of the original. In this instance, Columba disagreed with the judgment, which resulted in a battle known as the Battle of the Book, which has been suggested as an early example of a judgment being appealed. Moving forward about 900 years, we get to Gutenberg. So Gutenberg perfected the oil-based movable type printing press. Having previously failed in enterprises such as manufacturing and sale of polished metal mirrors, which were claimed to capture and retain holy light from religious relics. However, he did succeed with the printing press. And in 1455, he completed printing 180 copies of the Gutenberg Bible. So obviously the significance of Gutenberg is he created a mechanism by which copies of works could be made. As this technology spread throughout Europe, different regulations emerged relating to the control of printing presses. So in England, control was vested in the Stationers' Company, which was a livery company formed in London in 1403, receiving a royal charter in 1557. Now, the Stationers' Company held a monopoly over publishing under the Licensing of the Press Act 1662, which required them to act as censors in return for the exclusive power to print. It was the power of censorship that led to increasing protests by authors who sought to prevent the renewal of the Act that was required on a 2-yearly basis. And in 1694, Parliament refused to renew the Licensing of the Press Act. After a period of deadlock from 1694, the Stationers hit on the strategy of emphasizing the benefits of licensing to the authors of the work rather than to the publishers. So this resulted in this passage of the Statute of Anne in 1710. The Statute of Anne prescribed a copyright term of 14 years, whilst allowing an extension of a further term of 14 years, during which time only the printers to whom the author had licensed their work would be allowed to print it. Once this 28-year term expired, works entered the public domain and could be reproduced freely. As a result of this, London publishers who found their income eroded by Scottish printers who were publishing public domain works after that 28-year period sought to persuade the English courts that the Statute of Anne merely supplemented perpetual protection of common law, and they believed that the first publisher should enjoy. So this resulted in a famous case, or an interlude, known as the Battle of the Booksellers, which culminated in the case of Donaldson and Beckett in 1774, where many of the issues that we currently understand as relating to copyright were first aired in detail. This slide has a quote from the decision in the case of Donaldson and Beckett, which is interesting because it notes, I suppose, the kind of the sway in terms of what was being dealt with away from publishers towards the author. So I'll read you a quick extract from it, which is that Mr. Attorney General Thurlow opened as counsel for the appellants. He first entered into a minute investigation of the idea inculcated by what is called a publication. He then dwelt much upon the sense of the word property, defining it philosophically and in the separate lights of being corporeal and spiritual. The term literary property he in a manner laughed at, as signifying nothing but what was of too obtruse and chimerical a nature to be defined. The booksellers, he observed, exemplifying his observations by several cases, had not till lately ever concerned themselves about authors, but had generally confined the substance of their prayers to the legislature, to the security of their own property. Nor would they probably have, of late years, introduced the authors as parties in their claims to the common law right of exclusively multiplying copies, had they not found it necessary to give a colourable face to their monopoly. If there are any authors in the audience, some of that may be familiar to you in terms of dealing with your publishers. So moving on to the Copyright Acts. So basically the status quo then stayed from the period of the Battle of the Booksellers, so late 18th century until 1842, which marked the passage of the Copyright Act, which set copyright protection at the author's lifetime plus 7 years, or if their death occurred less than 42 years after publication, for 42 years from the date of publication. Changes to the categories of work protected by copyright resulted from case law and were applied to musical compositions and through legislation with the Engraving Copyright Act and the Fine Arts Copyright Act, which extended copyright to engravings, paintings, photographs, and drawings. The 1911 Copyright Act was the last Copyright Act the UK Parliament to have direct effect in Ireland, as it was the last Copyright Act to predate Irish independence. The 1911 Act implemented changes arising from the 1908 Berne Convention for the protection of literary and artistic works, namely abolishing common law copyright in unpublished works, and it added sound recordings to the categories of works to which copyright applied. The 1911 Act also extended the duration of copyright to 50 years after the author's death, along with other amendments, specifically in relation to copyright exemptions, which we'll talk about later, whilst also implementing copyright laws throughout the UK and the British Empire as it was at the time. The Industrial and Commercial Property Protection Act 1927 was the first copyright legislation passed by the Oireachtas of the Irish Free State, which retained the 50-year post-death copyright period. The Copyright Act of 1963 added, amongst other things, new media to the works protected by copyright. So the new medium of television broadcasts were added, and the 1987 Copyright Act introduced a new offence of public performance of copyright material where it was known to be copyright. So, copyright in Ireland. In Ireland, copyright is now governed by the Copyright and Related Rights Act 2000 as amended. Though in many cases, copyright law has been largely harmonized across the European Union. The CRRA only exists as an unofficial consolidated version, so you'll see the image there is taken from the title page of the unofficial consolidated version. So each of those color codes indicates a specific piece of legislation which has amended the Act. And in the unofficial consolidated version, you will see text in each of those colors, which has been added to the Act. So it badly needs to be an official consolidated version needs to be written and published. It clocks in at 297 pages. So it's probably one of the most sort of challenging pieces of statute in Ireland to read. Back to the European harmonization. So the InfoSoc Directive, so Directive 2001/29 EC 49 of the European Parliament and the Council, states that if authors or performers are to continue their creative and artistic work, they have to receive an appropriate reward for the use of their work, as must producers in order to be able to finance this work. It also states that a rigorous, effective system for the protection of copyright and related rights is one of the main ways of ensuring that European cultural creativity and production receive the necessary resources and of safeguarding the independence and dignity of artistic creators and performers. So copyright protection is also governed by international law under the Berne Convention for the Protection of Literary and Artistic Works, which was completed in Paris in 1886 and most recently amended in 1979. One of the basic principles of the Berne Convention are that works originating in one contracting state must be afforded the same protection in other contracting states as in the state of origin. Protection must not be conditional upon compliance with any formality, so protection is automatic, and protection is independent of protection in the country of origin, subject to potential expiry of protection in a contracting state if the country of origin defines shorter protection periods. So what this means is that if a contracting state defines a longer period of protection than the country from which the work originates, then the work in question is protected for the longer period. So as of 2022, there are 178 states who have become parties to the convention, so including the United Nations, the Cook Islands, the Holy See, and Niue, which is a self-governing island country in free association with New Zealand. So the CRA defines copyright protection in the following terms at section 17. So copyright is a property right, whereby, subject to this act, the owner of the copyright in any work may undertake or authorize other persons in relation to that work to undertake certain acts in the state, being acts which are designated by this act as acts restricted by copyrighting work of that description. So the significance of copyright being a property right is that property is a constitutional right. So the Constitution declares that the state will vindicate the property rights of every citizen. So that means that you have a right to own, transfer, inherit property. You have the right to bequeath property upon your death. The state guarantees to pass no law to abolish these rights. So the right to property is what's known as a fundamental right. However, it is not an absolute right. So Article 43 acknowledges that property rights ought to be regulated by the principles of social justice. So this means that the state may pass laws limiting your right to private property in the interests of the common good. So the most common example of that is taxation on ownership, transfer, or inheritance of property. Or, for instance, town and regional planning, or protection of national monuments, which may be on your land, or compulsory acquisition of land. And if the state passes a law that restricts your property rights, it may be required to compensate you for this restriction. But it's important to note that, as I said, property right is fundamental, but it is not absolute. Section 17 of the Act goes on to state that copyright subsists in accordance with the Act in original literary, dramatic, musical, or artistic works, sound recordings, films, broadcasts or cable programs, the typographical arrangement of published editions, and original databases. So obviously the distinction with the typographical arrangement of published edition is that is the specific typographical setting that the publisher produces rather than the work itself. Section 17.3 CRA notes that copyright protection shall not extend to the ideas and principles which underlie any element of a work, procedures, methods of operation, or mathematical concepts. And in respect of original databases, shall not extend to their contents and is without prejudice to any rights subsisting in these contents. I suppose the point there being that the compilation of the database requires creative input and skill, which are concepts we're going to look at a bit later on. So therefore, it is possible to have copyright in a database. However, databases normally comprise collections of other data, and the copyright does not extend to the data rather than the arrangement of the data. But we'll look at that a little bit more as we go further on. So What is a literary work? A literary work means any written or printed composition. So the requirement for originality relates to the expression of something in writing or print rather than the originality of the ideas expressed per se. To meet the threshold of originality, it is merely required that the author has made use of their skill, judgment, and labor in its creation. So this is the point that relates back to databases that we spoke about a second ago. The famous case in relation to skill, judgment, and labor is the case of William Hill and Ladbroke. So William Hill brought Ladbroke to court for infringement of copyright in compiled lists of fixed odds football betting coupons, which on first examination you would not assume to be a literary work. But despite the opinion of Lord Denning in his judgment that the coupons had no more appeal to the aesthetic sense than a set of logarithm tables or an income tax return, which are more apt to produce a feeling of revulsion than a sense of beauty, the work of compiling the lists required skill, judgment, and labor, and therefore was copyright. So this is a UK ruling, so it is what is known as not binding but persuasive. So UK rulings where something has not been decided in the Irish courts, judges in Ireland will often look to UK rulings, and UK rulings will often be presented by barristers making the case. Obviously, because we have a legal system which has diverged post-independence in 1922, UK rulings are not binding, but they can be persuasive. So in the sense that if, you know, football betting coupons, fixed odds lists can be literary works, the majority of records, books, audio recordings, video recordings, films, documents, and databases held by any gallery, library, archive, or museum are literary works. In the case of records created by a state body or institution, anything created prior to independence in 1922 and before the foundation of the Irish state are still Crown copyright. State records created after 1922 and after the foundation of the Irish state are Irish government copyright. And any works which are not state records are the copyright of the author. So what is an author? Helpfully, the Copyright and Related Rights Act gives us a definition of an author. And it says that an author means the person who creates a work and includes, in the case of a sound recording, the producer. In this instance, the producer not being the producer in the sense of the person who goes into the studio and works with the artists who are recording, but the person who is actually funding the recording. In the case of a film, including the soundtrack accompanying the film, the producer and the principal director. So again, the producer, the person who's funding the film, and the principal director being the person who's directing the film. In the case of a broadcast, the person making the broadcast, or in the case of a broadcast which relays another broadcast by reception and immediate retransmission without alteration, the person making that other broadcast. So it's basically the person making the original broadcast, written as the copyright. In the case of a cable program, the person providing the cable program service in which the program is included. In the case of a typographical arrangement of a published edition, the publisher. So this point again about the distinction between the author's manuscript and the typescript edition, the typographical arrangement. In the case of a work which is computer generated, the person by whom the arrangements necessary for the creation of the work are undertaken. In the case of an original database, the individual or group of individuals who made the database, and in the case of a photograph, the photographer. Obviously, the point there in relation to the work which is computer generated is something which is newsworthy at the moment with the advent of AI. There have been certain legal moves throughout Europe. So, for instance, in Italy, I believe that there is a proposal to impose a VAT on artificial intelligence generated content. In France, there's a push for AI generated content to identify the sources from which it created his work and compensate those people. But we might try and talk about that a bit more later on, depending on how much time we have. Okay. So in Ireland, in relation to litigation brought for copyright infringement, the Copyright and Related Rights Act presumes that copyright exists in the work unless otherwise proven. And it presumes that the plaintiff, so the person bringing the litigation for copyright infringement, is the holder of the copyright unless the contrary is proven. Section 37 of the CRA provides for the nature of the rights possessed by the copyright holder, and that anyone who performs one of these acts without the permission of the copyright holder is guilty of an infringement. So the rights in particular set out at 37.1 are to copy the work, to make the work available to the public, and to make an adaptation of the work. Section 39 details copying of a work, so as described in Section 37A under the heading of reproduction right, and states that copying will be construed as meaning storing the work in any medium. So for instance, digitizing a book or a recording and storing it on a server is counts as copying. Section 40 of the CRA expands on what constitutes making a work available. So making it available is making it available to the public copies of the work by wire or wireless means in such a way that members of the public may access the work from a place and a time chosen by them. So basically digitizing material and putting it up on the internet. Performing, showing or playing a copy of the work in public, broadcasting the work, or including a copy of the work in a cable program service. It also includes issuing copies of the work to the public, renting copies of the work, or lending copies of the work. So, copyright exhaustion. You may be experiencing this yourselves at this point in the talk, but it is actually an international legal doctrine. So, the principle of exhaustion acts to limit the control an original copyright holder can have over goods after their first sale by the copyright owner or their first sale on consent. So, for instance, where an author assigns their rights to a publisher, the publisher sells it, that is a sale on consent. So, what this means in broad effect is that the copyright owner cannot prevent the resale or loan of the work as the copyright is exhausted by the sale. So once it has been sold, the author or copyright owner cannot prevent it from being resold or loaned. So it's this principle that supports the lending of books by, for instance, public libraries, despite the fact that libraries have obviously existed for considerably longer than copyright law. So the oldest known library being that of Ashurbanipal in Nineveh in modern Iraq, which was founded in the 7th century BC. So libraries are older than copyright. So copyright duration, how long does copyright last? So the Copyright Term Directive 2006/116/EC is a European Union directive which harmonizes the term of copyright protection across the EU, and it was transposed into Irish law by the Copyright and Related Rights Act. Article 1 of the directive states that copyright shall run for the life of the author and for 70 years after his death, irrespective of the date when the work is lawfully made available to the public. The rights of performers last 50 years under the directive. The rights of sound recordings. So as of 2013, so where the rights of the performer and the producer would still have been protected on 1st of November 2013, or where the sound recording is created on or after 1st of November 2013 attracts 70 years protection. So what this means in effect is that anything from any recordings from 1962 or earlier are now public domain works. A musical work, as in the composition, is protected for 70 years from the death of the author. Films are protected for 70 years after the death of the last author or director of the film. Broadcasts are protected for 50 years after the broadcast was legally transmitted. On the expiry of the term of copyright protection, works are deemed to have entered the public domain. And what that means is they can be freely copied, distributed, reproduced, republished, translated, and pretty much used as however the kind of the republisher sees fit. The only restriction being artists' moral rights, which we will talk about a little bit later on. Of course, there are variations in copyright internationally. So obviously the Copyright Term Directive harmonizes the periods of copyright across the EU. But for instance, in the US, the Sonny Bono Copyright Term Extension Act of 1998, which related to works published between 1923 and the end of 1977, states that copyright lasts until 95 years after the year of first publication. Provided that for editions published in the US, the work was published with a copyright notice, and copyright in works published between 1923 and the end of 1963 was renewed. In Spain, copyright lasts for 70 years after death for authors that died on or after 7th December 1987. And for any authors who die subsequent to that, copyright lasts for 80 years. So to give you some examples of copyright terms, works of James Joyce, Joyce died in Zurich in 1941, are now public domain throughout Europe as 70 years have passed, where 80 years in Spain's case have expired. Whereas in the US, Holmes' Penny Each was published in 1927, is in the public domain. Ulysses was published in the US in 1934 by Random S, so that will not enter the public domain in the United States until 2030. Some of you probably be familiar with issues in relation to Joyce's copyright. So for instance, in 2004, when Joyce's works were still in copyright in Ireland, his grandson Stephen threatened to sue the National Library of Ireland for breach of copyright by displaying manuscripts and draft notebooks in a James Joyce and Ulysses exhibition, as well as threatening to sue if any public readings of Joyce's work featured in any celebrations. So for instance, the annual Bloomsday events on the 16th of June. Now that those works have entered the public domain in Ireland, people are obviously free to reproduce them and to read them in public at will. Another example is the first film that featured the character Mickey Mouse, which was the film Steamboat Willie, produced by Walt Disney. Steamboat Willie entered the public domain on the 1st of January 2024. It was initially released in 1928. So under US copyright law, characters can receive protection for 95 years, which means that more modern iterations of Mickey Mouse remain under copyright. So you'll see in the image there, while it is recognizably Mickey Mouse, it's not the same as the Mickey Mouse that appears in the merchandise throughout the Disney store. The name Steamboat Willie is separately protected by Disney as a trademark. And actually, the film has been made publicly available for many years on YouTube, courtesy of Disney. So very little is liable to change with it having entered the public domain. So I think that's probably as good a time as any to take a short break. There are some people in the meeting room that I'm just going to admit. Yeah, so what we'll do is we will take a break, say 15 minutes. If we come back at 5 to 11, we'll move on to the next part of the presentation, which will be addressing copyright exceptions for galleries, libraries, archives, and museums. Daphne, does that make sense? Daphne?
Yes.
Yeah. Okay. So we'll take a short break until 5 to 11.
Of course.
Perfect. All right. Okay. See
Thank you.
everyone then. Thank you.
if you search for your camera to turn off the camera, it is on the bottom. Okay, great. Okay, we are back.
I think there's a couple of people in the waiting room there, Daphne.
As you are the presenter, you may let them in. I do not have any more this command. Otherwise, I will change the file.
Okay.
Thank you.
Okay, they're in now. Welcome to everyone who's just joined us. Hi, Samantha. Thanks for joining.
Hi, how are you?
I'm good, thank you. I'm just battling somewhat with Zoom. We're going to start again in a couple of minutes. I'm just trying to figure it out.
Well, yeah, we're here because we're interested, obviously, in what are the concerns
Yeah.
in the area, but we're also planning to do an information sheet on Out of Commerce within the next week. Well, we started planning it yesterday, so
Okay.
we'll have a separate page on our website around Out of Commerce and
Okay.
that kind of. But anyway, enjoy it.
Very good. I mean, I'm going to touch on Out of Commerce Works in the next section, and obviously it'll be including what we discussed.
Yeah.
But if at the end there's going to be a Q&A at the end, so if there's anything that I have got
Yeah.
wrong or that you would like to add, then
That's
please
great. Thank you.
do feel free to jump in at that point.
Thank you.
Now, can I get my screen sharing to work? So, Daphne, do you think, are we ready to resume? Is it okay to start?
Yes, of course, we can start.
Yeah. Okay. So thank you everyone for your attention during the first half. This second section, I'm going to be dealing more with copyright exceptions. So things that you are allowed to do as a cultural heritage institution. So hopefully that this will be of more direct interest to all of you. So the first exception that we're going to talk about is an orphan work. So an orphan work, as the name implies, is a work whose author either cannot be identified, or if they can be identified, can't be located. Under Irish law, it's governed by the European Union, Certain Permitted Uses of Orphan Works Regulations 2014. So what these regulations require is that a diligent search be carried out. So it includes definitions of what a diligent search entails. So that includes searching the database and established and managed by the Office of Harmonisation in the Internal Market in accordance with Regulation EU number 386/20123. The appropriate source is relevant to the category of relevant work as specified in the schedule, and if there is evidence to suggest that relevant information on rights holders is to be found in other countries, sources of information available in those other countries. The relevant body seeking to use the work, so that is the Cultural Heritage Institution, must maintain a record of each such diligent search. So for each orphan work that you have that you wish to use, you need to keep a specific record detailing the steps undertaken in the diligent search. That information then needs to be provided to the Controller of Intellectual Property, who is based at the Intellectual Property Office of Ireland, as specified in the regulations at section 5.3. So the results of the diligent searches which the relevant body has carried out and which have led to the conclusion that the relevant work is considered to be an orphan work, the use that the relevant body makes of the orphan work concerned, any change pursuant to Regulation 7 of the orphan work status of any relevant work used by the relevant body and the relevant contact information of the relevant body. The controller, so based in the Intellectual Property Office of Ireland, will then forward that information to the Office for Harmonisation in the Internal Market in order for the recording of that information on the online database established and managed by that office. Once recorded on this database, certain uses of orphan works are permitted, as described at Section 8 of the regulations. So namely, namely making the orphan work available to the public, and we've discussed in the previous session what making available to the public means, and an active reproduction of the orphan work for the purposes of digitization, making available, indexing, cataloging, preservation, or restoration. So Section 8.3 of the regulations in relation to orphan works states that the orphan work exemptions listed above, so in other words, making the work available to the public, reproducing it for digitization, making available, indexing, cataloging, preservation, or restoration, only relate to instances where a relevant body shall use the orphan work only in order to achieve aims related to its public interest mission. And in particular, in relation to the preservation of, the restoration of, and the provision of cultural and educational access to relevant works contained in its collection. So basically what this means is non-commercial uses that are related to the mission of the Cultural Heritage Institution. Section 8.4 of the regulations allows for the generation of revenue, but only so far as it is necessary to cover the costs of digitization and making available to the public. Section 8.5 states that individual authors and rights holders in the orphan work must be credited. So as a result of the above, relevant bodies, cultural heritage institutions are free, having carried out the diligent searches, to digitize and make those works available to the public. So including digitizing and putting them online. They are allowed to charge to cover their costs as long as the authors or the rights holders are credited, and the motivation for the digitization is the body's public interest mission. So in other words, that it is undertaken on a non-commercial basis. So the next exception we're going to talk about is fair dealing. Fair dealing is dealt with under the Copyright and Related Rights Act at Chapter 6, which details acts permitted in relation to works protected by copyright. So the first of these acts is in relation to fair dealing. So Section 51 explains that fair dealing with a literary, dramatic, musical, or artistic work, sound recording, film, broadcast, cable program, or non-electronic original database for the purposes of research study shall not infringe any copyright in the work. Right. So we've seen this list of works, what comprises a work previously, but this states that fair dealing does not infringe any copyright in the work. So what does fair dealing mean? Section 54 states that fair dealing means the making use of a literary, dramatic, musical, or artistic work, film, sound recording, broadcast, cable program, non-electronic original database, or typographical arrangement of a published edition. Again, typographical arrangement, the distinction here between the published version and the author's manuscript, which has already been lawfully made available to the public for a purpose and to an extent which will not unreasonably prejudice the interests of the owner of the copyright. Fair dealing is allowable for a number of purposes. So criticism or review, making copies of part of a copy of work. So other than a photograph on current economic, political, or religious matters made by a media business. So basically quoting from a work for criticism or review, or reporting on economic, political, or religious matters. Making copies in the course of education or preparation for education, so primary, secondary, third level education, unless it is carried out by a reprographic process. So for instance, photocopying in which case an Irish Copyright Licensing Agency license is required, and that sufficient acknowledgement is included. So the Irish Copyright Licensing Agency, the ICLA, provides licenses to educational establishments, to general businesses, administration, law firms, pharmaceutical companies, which allow for the copying and making available of copyright material under strict restrictions which are set out. And ordinarily this means that no more than 10% of a total work or one chapter of a book can be copied and made available under the license. Obviously, the rationale here being that the license doesn't allow you to copy works wholesale, because this would infringe on the rights of the rights holders. The ICLA temporarily increased the percentage of the book that was available under the license to 20% during the COVID pandemic period. As far as I'm aware, this has been reduced back to 10%, but Samantha from the ICLA is actually joining us today, so she might clarify that when we get to the Q&A at the end of this session. So more on fair dealing. So fair dealing is addressed within the context of the Berne Convention at Article 10. So the Berne Convention states that quotations from a work which has already been lawfully made available to the public. Again, we've spoken about what making available to the public means. It means publishing, broadcasting. Quotations are permissible and that their extent does not exceed that justified by the purpose, as long as mention is made of the work and the author is credited where known. So you're allowed to quote from copyright works as long as the extent of the quotation does not exceed that justified for the reason to use it, and you must mention the work and you must credit the author where you know them. Other aspects of fair dealing are caricature, parody, and pastiche, and they do not infringe copyright in that work. So this begs the question, what's the difference between caricature, parody, and pastiche? So we have a number of sort of international sources that can give us some guidance on this. The UK Intellectual Property Office guidance from 2014 states that caricature portrays its subject in a simplified or exaggerated way. The CJEU defined parody as evoking an existing work while being noticeably different from it, and constituting an expression of humour or mockery. There have been no judgments that I am aware of that address the exact meaning of pastiche. So there is a definition from the Oxford English Dictionary, which is as good as we're probably going to get, which says that pastiche is an artistic work consisting of a medley of pieces imitating various sources. So this obviously has significant implications, for example, for AI-generated artworks, because AI-generated artworks are a medley of pieces imitating various sources. Specifically for artworks, there are a number of exemptions defined within the Copyright and Related Rights Act. So under section 94, it states that it is not an infringement of the copyright in an artistic work to copy it or to make available to the public copies of it for the purposes of advertising the sale or public exhibition of the work if the copying is done and the copies are used only to an extent reasonably justified for achieving that purpose and for no other commercial purpose. So in other words, it is okay for auction houses to have copies of the works in their brochures for the auctions. It's okay for galleries to copy the artworks, to use them to advertise the existence of the exhibition in which that artwork is featured. Section 95 states that where the author of an artistic work is not the copyright owner, it is not an infringement of the copyright in the work to copy the work in making another artistic work, where the author does not repeat or imitate the main design of the earlier work. Okay. So, exemptions for librarians and archivists. So the Copyright and Related Rights Act allows for a number of important exemptions for librarians and archivists. The reason these exist is to allow them to carry out their core functions, which are preserving works and making them available to researchers and or the public. So under Section 64 of the Copyright and Related Rights Act, librarians or archivists are allowed to make and supply to another prescribed library or prescribed archive a copy of a periodical or articles or the contents page contained therein and the whole or part of a work which has been lawfully made available to the public. It's important to note that these exemptions only apply where the librarian or archivist could not reasonably have obtained the consent of the author or the rights holder. Sorry, just somebody else in the waiting room. There we go. There's a further exemption which allows for copying for preservation purposes, which is detailed at Section 65 of the Copyright and Related Rights Act. So this allows the preservation or replacement of a work. Allows copying for preservation or replacement of a work in addition to or in place of the original. So replacement of a work from the permanent collection of another prescribed library or archive which has been lost, destroyed, or damaged. So in other words, if you have a copy of a work that the other library or archive used to have, which has been lost or damaged, it is allowable to digitize that work to provide them with a copy of it. It's important to note that these exemptions do not apply where it is reasonably practical to purchase a copy of the work concerned. Copyright and Related Rights Act does not give us any guidance on what reasonably practical means. I would venture to say it means if the work is commercially available. So in other words, if it is purchasable either from, a shop, an auction site, a dealer, then it probably is reasonably practical to make a purchase. Obviously, if it's not available commercially, then it is not reasonably practical, in which case it's probably reasonable that you could say that you could rely on Section 65 in this instance. So more exemptions for librarians and archivists. So Section 68 allows for the making of a copy of a work in the permanent collection of a prescribed library or archive. So this is not material that you have borrowed from elsewhere. Allows for the making of a copy in a different form. So what this is really talking about is digitization. If lawful means are used to make the copy, and the copy is made solely for preservation or archival purposes that are not directly or indirectly commercial. So again, solely for preservation reasons, so as a backup, or archival purposes, not in order to charge for access to it. It's arguable, and I have argued this, that the best way to preserve any book or document is to digitize it and then only make the digital copy available to researchers to reduce wear and tear on the original. This, of course, obviously saves the staff time in retrieving the original, supervising the researcher, packing, unpacking, etc. Section 68(3) states that any contractual provisions contrary to this section shall be unenforceable. So what this means that a rights holder cannot impose conditions on a library or archive to prevent preservation digitization. So if you are purchasing materials, the person from whom you are purchasing them cannot impose contractual provisions saying that you're not allowed to digitize it, because Section 68 of the CRRA will override any such provision. Under Section 69A of the Copyright and Related Rights Act, the librarian or archivist of a prescribed library or prescribed archive may make available to members of the public copies of works in the permanent collection of the library or archive by dedicated terminals on the premises of the library or archive, where undertaken for the sole purpose of education, teaching, research, or private study, and accompanied by a sufficient acknowledgement. So what this means is that libraries or archives are free to digitize the contents of their permanent collections. So again, not material that is on loan, and make those works available to researchers, members of the public, for the purposes of education, teaching, research, private study on dedicated terminals. So basically on computers in the physical premises of the library or archive. What this does not allow is digitizing and placing works online. It's important to note that Section 70 very specifically says that copies made under any of the exemptions above cannot be sold, rented, or lent. So it would be treated as an infringing copy. So in other words, you cannot, as a library, digitize a copy of a book for the purposes of lending it, because otherwise it will be an infringing copy. You can digitize it for the purposes of preservation. You can digitize it to fill gaps in other libraries' collections. Sorry, no, something else in the waiting room. And you can digitize it to make it available for education, teaching, research, or private study if it's accompanied by sufficient acknowledgement, and then only on dedicated terminals. So the summary there, making of copies is allowable by librarians and archivists for preservation purposes, to supply a copy of work to another library for non-commercial preservation or archival purposes, or to make copies available at dedicated terminals on the premises of the library or archive. So the next exemption is in relation to DSM. So the EU Directive on Copyright in the Digital Single Market, which is much more manageable as DSM, was transposed into Irish law by Statutory Instrument 567 of 2021, which is the European Union Copyright and Related Rights in the Digital Single Market Regulations 2021. So what the DSM directive states at Article 8 is in relation to the use of out-of-commerce works and other subject matter by cultural heritage institutions. So what is an out-of-commerce work? So helpfully, the DSM defines it for us at Article 8.5, and it says that an out-of-commerce work is a work or other subject matter shall be deemed to be out of commerce when it can be presumed in good faith that the whole work or other subject matter is not available to the public through customary channels of commerce, so it is not purchasable, after a reasonable effort has been made to determine whether it is available to the public. DSM doesn't define what a cultural heritage institution is, and neither does the SI that transposes it. It does state in the recitals that a cultural heritage institution should be understood as covering publicly accessible libraries and museums, regardless of the type of works or other subject matter that they hold in their permanent collections, as well as archives, film or audio heritage institutions. They should also be understood to include inter alia national libraries, national archives, and as far as their archives and publicly accessible libraries are concerned, educational establishments, research organisations, and public sector broadcasting organisations. So what can the cultural heritage institutions that we just detailed do under the terms of the DSM? This is dealt with as a Regulation 8.1 of SI 567, which is the Irish Statutory Institute which transposed the DSM into law. It addresses the use of out-of-commerce works by cultural heritage institutions, and it states that a collective management organisation may, in accordance with its mandates from right holders, conclude a non-exclusive license for non-commercial purposes with a cultural heritage institution for the reproduction, distribution, communication to the public, or making available to the public of out-of-commerce works or other subject matter that are permanently in the collection of the said cultural heritage institution, irrespective of whether all right holders covered by the license have so mandated the collective management organisation. In the case of Ireland, the collective rights institution is the Irish Copyright Licensing Agency, who we spoke about before. And provision is also made within the regulations for the right holders to exclude their works from the licensing mechanism. Samantha, as I said, from the ICLA is with us today. She might clarify this at the end in the Q&A, but my understanding of the current situation is that the ICLA, while it has not concluded any licenses for out-of-commerce works with cultural heritage institutions, it is currently looking into its position in relation to the basis of its mandates, sufficiently representative right holders in the relevant types of works and the types of rights that are the subject of the license. So what this means in brief is that out-of-commerce works, as we've seen, are works which are basically not commercially available after sufficient investigation has been undertaken by the Cultural Heritage Institution. If they are out of commerce, the Cultural Heritage Institution is entitled to copy them under license from, in Ireland, the case would be the ICLA. In instances where the ICLA does not have mandates from right holders for the types of material which the Cultural Heritage Institution is interested in digitising, then it is possible for the Cultural Heritage Institution to digitise and make those available without a licence. So Regulation 8.9 states that 6 months before the work or the subject matter licensed is distributed, communicated to the public, or made available to the public, cultural heritage institutions, collective management organisations, and library authorities within the meaning of Section 32 of the Local Government Act shall provide the following information on the Out of Commerce Works portal, which was established by the European Union Intellectual Property Office. So the information that's required to be supplied before making the digitised material available, so 6 months before it's made available, the title of the work, where possible the author, and a brief summary of the contents of the out of commerce work that is proposed to be the subject of a licence must be provided to the portal. So the portal is maintained by the European Union Intellectual Property Office. At the time of writing, there are no entries from Ireland at all on this portal. Where no collective management organisation exists, or where no collective management organisation has a sufficient mandate from right holders in relation to the types of material to be digitised, this is addressed at Regulation 9, which amends the Copyright and Related Rights Act by inserting the following section after Section 58, which says that it is not an infringement of the rights conferred by this part for a cultural heritage institution to make available for non-commercial purposes. Again, very important that this just relates only to the mandate of the Cultural Heritage Institution. For non-commercial purposes, out of commerce works or other subject matter that are permanently in its collections, where no collective management organisation exists, and it is accompanied by sufficient acknowledgement. So again, acknowledge the name of the author, the name of the work, and such work is only made available on non-commercial websites. So in other words, it cannot be put behind a paywall or a subscription website or pay-to-view website. Provision is also made for right holders to exclude their works from the licensing mechanism, and there is a similar requirement for publication on the EU IPO. So Regulation 9 doesn't apply to sets of out-of-commerce works or other subject matter if they predominantly consist of works other than cinematographic or audiovisual works, first published or, in the absence of publication, first broadcast in a third country. Cinematographic or audiovisual works of which the producers have their headquarters or habitual residence in a third country, or works of third country nationals where, after a reasonable effort, no member state or third country could be determined. So, lending of works. So lending is covered under Directive 2006/115/EC of the European Parliament and the Council of 12th of December 2006 on rental right and lending right, and on certain rights relating to copyright in the field of intellectual property. So what that says at Section 3 is that the adequate protection of copyright works and subject matter of related rights protection by rental and lending rights, as well as the protection of the subject matter of related rights, protection by the fixation right, distribution right, right to broadcast and communication to the public can accordingly be considered of fundamental importance for the economic and cultural development of the community. Article 2b of the directive states what lending means. So basically lending means making available for use for a limited period of time and not for direct or indirect economic or commercial activity. When it is made through establishments which are accessible to the public, so basically public libraries. Article 3.1 states that the exclusive right to authorise or prohibit rental and lending shall belong to the author in respect of the original and copies of his work. Article 3 states that the rights referred to in paragraph 1, which is the right of the author to prohibit rental and lending, may be transferred, assigned, or subject to the granting of contractual licenses. So what this means is that the author or the rights holder and the publisher, if they've transferred their rights, may object to the lending of their work. So this begs the question, well, how are you able to borrow books from a library? And the answer is that there's a derogation which exists at Article 6 of the directive, which states that member states may derogate from the exclusive right provided for in Article 1, which is the right to object to lending, in respect of public lending, provided that at least authors obtain a remuneration for such lending. So in other words, you can derogate from the exclusive right of authors or rights holders to prevent lending as long as they are paid for this lending. So this payment, this remuneration, is known as public lending remuneration, PLR. Member states are allowed to exempt certain categories of establishments from paying PLR. So in Ireland, educational bodies are exempt from paying PLR, but public libraries are required to pay it. However, the fact that educational establishments are exempt from paying it does not mean that authors and rights holders are entitled to rely on Article 1 to prevent the lending by educational establishments. So one does not affect the other. The Copyright and Related Rights PLR scheme regulations of 2008 established a scheme to be known as the Public Lending Remuneration Scheme to remunerate authors out of monies voted by the Oireachtas for the purpose for the lending by public libraries of qualifying works being eligible books and posthumously eligible books within the meaning of Article 7 and 8 of the scheme, respectively. So what happens is that the Oireachtas votes for a sum of money, which is the fund from which PLR is paid out, and then that is paid out fractionally to authors based on the number of loans of their books within a 12-month period. Section 42A of the Copyright and Related Rights Act helpfully defines a public library as a library to which members of the public have access, so that is operated by or under the direction of a library authority within the meaning of Section 77(1) of the Local Government Act 2001. So what that section states is that a library authority is a county council, a city council, and a city and county council. So any of these councils operate public libraries within their own authority. Who manages PLR in Ireland? It's managed by the Local Government Management Agency, the LGMA, and it is paid out to authors by the Irish Copyright Licensing Agency, the ICLA. So the thorny issue of PLR and ebooks. So the position in EU law as to whether the PLR directive on rental right and lending right applied to ebooks basically has been in doubt since the introduction of ebooks as a reading format. And the reason for that was that publishers have argued that the format of ebooks is a completely distinct and different beast than the published book, and that it is only possible to access ebooks through licensing. It's not possible to purchase them, and it's not possible to lend them under the normal mechanisms. I'll get into this in a bit more detail in a couple of minutes. But the ruling in 2016, which is Vereniging Openbare Bibliotheken versus Stichting Leenrecht Vereniging Openbare Bibliotheken, which is, for obvious reasons, more frequently referred to as VOB. In this case, it was a library association. So every library, public library in the Netherlands belongs to this library association. And it brought an action against Stichting Leenrecht, which is the foundation entrusted with collecting PLR. So it was looking for a declaratory judgment, so a statement to the effect that the regime for traditional books should also apply to public lending. So what this means is that the action concerned lending under the one copy, one user model. So the way it works with a physical book, a library buys a copy of the book, it can then lend a copy of the book. This looked into the question of whether this was applicable to ebooks. So namely the lending of an electronic book carried out by placing that copy on the server of a public library and allowing the user concerned to reproduce that copy by downloading it onto their own computer. Bearing in mind that only one copy may be downloaded during the lending period, and that after that period has expired, the downloaded copy can no longer be used by that user. And the way that that would be achieved is obviously there are technical protection measures that can be used that limit whether a downloaded copy of a book can be copied, the period of time under which it can be accessed by the user, and so forth. So there are technical mechanisms that allow this. What the ruling in VOB clarified is that the lending of electronic materials falls within the scope of PLR directive. So this means that libraries can derogate from the rights of authors and rights holders to prevent lending. So this is the Article 1 derogation we spoke about before, providing PLR is paid, subject to certain bodies being exempt from PLR, which is the educational institutions we spoke about before, and that provision is made for ebooks in national PLR regulations. So here's the rub. This is the important thing, that provision is made for ebooks in national PLR regulations. So the Irish Copyright and Related Rights Public Lending Remuneration Scheme regulations of 2008 transferred the PLR directive into Irish law. And Article 7.2a of the PLR regulations defines a book as a printed and bound publication, including a paperback edition. So what is significant about this is that there is no other piece of statute at Irish law which tells you what a book is. Copyright and Related Rights Act speaks almost exclusively about works. So obviously we know that works can be, you know, a book, a poem, a photograph, a painting, a film, sound recording, a musical composition. You know, at no point has there been any attempt to define what a book is, or to say that a book is a printed and bound publication. It's also significant that within the Copyright and Related Rights Act, under the legal deposit terms, it states that legal deposit libraries may request a copy of a book in electronic format. So the CRA states that a book can exist in electronic format. However, the wording in the PLR regulations very, very succinctly and deliberately excludes ebooks from the PLR regulations, which begs the question, you know, what was the motivation behind drafting it in that way? In contrast, in the UK, PLR was extended to ebooks and audiobooks by the Digital Economy Act 2017. But even that included the caveat in that it applies to an ebook or an audiobook only if lending is in compliance with any purchase or licensing terms to which the book is subject. So we've seen beforehand in relation to exemptions for libraries and cultural heritage institutions, you know, the exemptions within the Copyright and Related Rights Act that allow copying, which also state that these cannot be overridden by contractual terms. Because the entire purpose of the exemption is to allow cultural heritage institutions to do what they're supposed to do. However, in this, the UK PLR provisions under the Digital Economy Act, it states that specifically publishers are allowed to impose licensing terms. So this allows publishers and third-party intermediaries to continue to set terms in relation to price, availability, technical protection measures, TPM, DRM, digital rights management, and also the bundling of titles with other titles and remote removal of access to titles. So in other words, the libraries are finding it increasingly difficult to say, I want a copy of this book in electronic format or an ebook, if you will, because publishers say, well, I'm sorry, that's only accessible as part of our library of books on this subject. You have to license all of the books. And we don't guarantee access to the particular book that you want as part of that bundle because it can be removed from the bundle at any time. So this is obviously very problematic for libraries because in contrast with the regime that exists for physical books, where we know the law, we know from copyright exhaustion that we dealt with in the first session that a library can purchase a physical copy of a book at which point copyright is exhausted and it can be lent. This doesn't exist for ebooks or electronic formats of books. So in Irish law, as there's no provision for PLR for ebooks or audiobooks within the Copyright and Related Rights Act, PLR remuneration regulations 2008, it means that the lending of ebooks and audiobooks can only be carried out under license on an ad hoc basis by libraries and educational establishments contracting directly with publishers and third-party intermediaries. So what this means is that publishers can effectively set whatever terms they want for ebooks. They can charge whatever they want. You know, you will often see pricing multiples of, you know, a 30-euro book might be 300 euros to license as an ebook. There was a parliamentary question asked recently of the Minister for Department of Further Higher Education, Research, Innovation and Science, where they were asked about the issue of spiraling costs of ebooks. And the Minister's response was that it is the responsibility of the Department of Enterprise, Trade and Employment, who have jurisdiction over copyright, to make any necessary changes to the PLR regulations to allow payment of PLR on ebooks. But he also stated that each educational institution is an independent body, and therefore government will not get involved in contractual regulations. So one of the kind of basic tenets of contract law is that everybody is able to enter into whatever contractual terms they wish. So at the moment, the publishers are pretty much able to dictate those terms, and libraries either have to accept it or not. There's a link there to a very good article, which is an RTE brainstorm, which was written by Cathal Macaulay, who's the university librarian at Maynooth University, and also Stuart Hamilton, who is from the Local Government Management Agency, and I have a little bit of input into that as well, but that would be worth reading if you're interested in this area. You know, and I suppose on the question of like, why is this ebook issue important? Why does it matter? So LIBER, which is the Ligue des Bibliothèques Européennes de Recherche, which is a professional association of national university research libraries, put it quite succinctly in saying that Article 11 and 14 of the European Charter of Fundamental Rights of the EU give European citizens the right to receive information regardless of frontiers, and the right to education and continued training. Lending and e-lending by public libraries support both these rights. With ebooks, however, the right of libraries to buy any book and lend it is currently being severely challenged. Public libraries are not able to support education and learning in the way they used to because they are no longer free to buy and lend any book available in the marketplace. Libraries across Europe are reporting problems buying, licensing, and lending ebooks to members of the public. Even where books are not available electronically, libraries do not have the right to digitize and then lend the books. So we've seen this in the Copyright and Related Rights Act exemptions. You can digitize books for preservation purposes. You can digitize them to fill holes in other bodies' collections. You can digitize materials and make them available in dedicated terminals in the library, but you cannot digitize and then lend them. So while applying payment to authors in line with the PLR. So the problems are not technological. In fact, technology can be used to ensure that frictions or differentiators exist so as not to undermine viable ebook markets. In some cases, libraries are unable to purchase the material because publishers refuse to sell to them. Some publishers offer artificially higher prices to libraries, making it difficult for libraries to purchase the range of titles their patrons want. Impractical licensing models are not uncommon, and not all books are available in electronic form. I suppose that, you know, the last point, just before we move off from this, the German government commissioned a study in relation to the economic impact of ebooks on publishers, which is one that's often relied on by people who are, I suppose, promoting the side of the publishers in insisting that, you know, licensing terms should be continued rather than allowing payment of PLR on ebooks. But, you know, if you look at the statistics behind the German report, you will see things like, you know, a sample of 84 people whereas obviously, you know, the population of Germany is north of 60 million. So I would question the veracity of some of those statistics. Okay. So we'll talk a little bit about some of the rights of authors, which are not copyright rights. So moral rights. What is a moral right? It's a proprietary right which protects the personality of authors as expressed in their creations alongside their economic interests and exploitation. So personality of authors, it's the intention of the author in terms of the use of their work. The Berne Convention recognizes two moral rights of authors, or it requires that two moral rights be recognized. So first is the attribution right, which is the right to be identified as the author of the work. The second right is the integrity right, which is the right to object to any distortion, mutilation, or other modification of, or other derogatory action in relation to the work, which would prejudice his or her reputation. Now, obviously, if you're looking at the exemptions around sort of parody, pastiche, caricature, you can see how that might rub up against the integrity right. So the right to object to distortion, mutilation, or modification of a work. But the integrity right also apply in relation to an adaptation of the work. So for instance, if I were to write a novel and it would be turned into a Broadway musical, I still maintain the integrity right in relation to that adaptation. In Irish law, moral rights are addressed at Chapter 7 of the Copyright and Related Rights Act. So in addition to the attribution right, which is the right to be recognized as the author of the work, a paternity right exists. So that is the author's right to be identified as the author of a work, which applies to the right to be identified as the author of any adaptation of the work, which are subject to exceptions similar in scope to those outlined under the fair dealing. So this is the issues around, quotation for reporting, quotation for educational purposes, pastiche, parody, caricature. So to give you an example of the kind of issues that might be dealt with under the heading of moral rights. So in 2023, the British Museum, somewhat embarrassingly for them, I suspect, settled a case in relation to the moral rights of a lady called Yilin Wang, by using her translations of the works of the Chinese poet Hui Jin, excuse my pronunciation, which it did without permission, credit, or payment. And it used these in the China's Hidden Century exhibition. In a statement put out by the museum, it said that it is reviewing the permissions process it has in place for temporary exhibitions, particularly with regard to translations, to ensure that there is a timely and robust methodology underpinning our clearance work and our crediting of contributors going forward. So the takeaway there for CHIs is if you are using other people's work and it is not subject to the exemptions listed under fair dealing or the exemptions under the Berne Convention, just be very careful that you properly attribute any of those quotations and, where relevant, make suitable payment for them. Another interesting case was in relation to the cartoonist Bill Tidy, which was a case brought by Tidy against the trustees of the Natural History Museum. So Bill Tidy had a popular series of cartoons of dinosaurs. The Natural History Museum reproduced these cartoons, which had originally been on white backgrounds, in reduced format, reduced size, and printed them on yellow and pink backgrounds. The case he brought was that this was a breach of copyright and moral rights. Obviously, they used the cartoons without permission, so this was a very clear breach of copyright. But it was interesting that the assertion that reducing their size and printing them on different backgrounds was derogatory treatment was dismissed. So again, this relation to the integrity right. So the right to object to any distortion, mutilation, or other modification of. So the printing on pink and yellow paper and reducing the size didn't meet the criteria to count as that mutilation. Okay, artists' resale rights. So ARR originated in France. That was known as the droit de suite. So that ensures that artists who sell a work in the early stages of their career at a low rate benefit from subsequent sales of the work by galleries and collectors as their prominence and collectability increase. So basically, if you are a final year art student at NCAD and Saatchi Gallery buys your entire collection and they subsequently resell it without the artist resale right, a painting that you sell for €1,000 and subsequently sold for €10 million, you get none of that. You do not enjoy any of the uptick in the value of your work. So that is the purpose of the ARR. Artist resale rights have been in existence in Ireland since 2006. So in order to qualify for payment of ARR, the work must be in copyright. So this also applies to the heirs of the artist if it's within 70 years of their death. It must be a second or subsequent sale of the work, so it doesn't apply to the first instance sale. The work must sell for €3,000 or more, and the work must be sold through a gallery, an auction house, or an art dealer. And ARR is payable on a sliding scale based on the sale price of the work, subject to a maximum payment of €12,500, which is obviously significant, but if you are Damien Hirst or somebody in that level of art sales, you see that it's a relatively small amount of money compared to what paintings might sell for. Liability for the payment rests with the seller and the art market professionals responsible for the sale. ARR in Ireland is collected by the Irish Visual Artists' Rights Organisation. So the seller or their agent need to provide the information necessary to secure the payment of the royalty within 90 days of the sale. Article 2 defines the types of artworks that are included in ARR, so original works of art, or copies of works of art, which are made in limited numbers by the artists themselves, so in other words, editions or a series of prints. Such copies will normally have been numbered, signed, or otherwise duly authorized by the artist. Outside the EU, ARR exists in the UK and Australia, but is not enforced in the US, China, Switzerland, or Japan. So sales to these countries from an EU country will not result in a payment to the artist. So if you are selling your works, be careful where you are selling them. So digitization and copyright law. So we've spoken about digitizing and lending and making available to the public copyright works within cultural heritage institution frameworks above. But the question is, what copyright applies to the digitized version? So museums, cultural heritage institutions often assume that a digitized image of an item which is public domain, so in other words, something which they are allowed to digitize and put online, so whether that be public domain or out of commerce works as defined under the DSM, are subject to their own copyright through the act of generating the image. So they're working on the assumption that generating the image is sufficient to meet the requirements defined in the Copyright and Related Rights Act, that copyright subsists in original literary, dramatic, musical, or artistic works. So what is original? We've seen in the Ladbrokes case that it was to do with original creative work. Okay, so the issue of whether new copyright is created in digitized works was addressed by a judgment of the UK court in THJ and Sheridan, which stated that is required that the author is able to express their creative abilities in the production of the work by making free and creative choices so as to stamp the work created with their personal touch. This criterion is not satisfied where the content of the work is dictated by technical considerations, rules, or other constraints which leave no room for creative freedom. So, okay, this is a UK judgment, so it is persuasive, but it is not binding. But typically galleries, libraries, archives, museums have claimed full copyright over digitized materials or have used Creative Commons licenses. whilst also looking for fees for reproduction of digitized images of materials which they have digitized, which are either public domain or out of commerce works. But what the judgment in Sheridan dictates is that no new copyright arises in the production of faithfully digitized images of public domain materials, where the original work being digitized is two-dimensional. The reason for this being that the limitation of the making of free and creative choices so as to stamp the work created with the personal touch. So as it says, the criterion is not satisfied with the content of the work, it is dictated by technical considerations, rules, or other constraints. So typically, if you're a cultural heritage institution and you are digitizing two-dimensional paper-based materials, you will digitize at a set number of DPI. So the National Archives digitizes at 450 DPI. That is the technical consideration. It digitizes using either a flatbed scanner or an overhead scanner. That's a technical consideration. It's not allowing the person making the digitization to make free and creative choices. So I would argue that there is no new copyright created where copyright did not exist in that material previously, which then begs the question, why is the material being put online with Creative Commons licenses, or on what basis is payment being sought to use it? I mean, we have seen that obviously within the exemptions, cultural heritage institutions are allowed to charge to cover their costs, but most of the exemptions in relation to work which is in copyright require that it be made available non-commercially. So it's a question worth considering why public domain works, when they're digitized, cultural heritage institutions can seek payment for reuse of them. So this is a UK ruling, so it is, as I said, persuasive but not binding. It does appear to be supported by Article 14 of the DSM that we looked at previously in relation to out of commerce works. So the DSM states that member states shall provide that when the term of protection of a work of visual art has expired, any material resulting from an active reproduction of that work is not subject to copyright or related rights, unless the material resulting from that active reproduction is original in the sense that it is the author's own intellectual creation. So what about images of objects? So three-dimensional works. So that this would appear to be different. So again, a UK case, so which is again persuasive but not binding. Antiquesportfolio.com versus Fitch and Co. So it held that copyright protection did extend to images of antiques. So the capture of the images required skill and effort in positioning the items, lighting the items, choice of details to highlight, and the angle of the photograph. And it states that this protection could safely be seen to extend to the plastic arts. Photographing a painting, whilst not dealt with in that case, I would argue requires skill and effort to ensure that the image is appropriately lit. Oil paintings, depending on the level of detail you get into in the image, are certainly three-dimensional. But I guess what is harder to defend is the use of a flatbed scanner, book scanner, or another orbital camera if it's used to capture a series of documents using predetermined resolution, color, and size settings. The John Paul Getty Museum in Los Angeles released 88,000 images of artworks in its collections under a CC0 license. So that, in effect, is a mechanism that announces to the users that the creator of the works asserts no copyright over them. The museum actually actively encouraged the use of the works through its social media channels, encourages people to, download, edit, repurpose high resolution images to print them on, t-shirts, to use them for whatever purposes they want. This results in a huge uptick in the number of users to the site and actually downloads from the site, which ended up at about 30,000 downloads per month. Okay, so that brings us to the end of the formal presentation aspect. Does anybody have any questions? Sorry, I'll stop sharing my screen. Oh, hang on. Any questions?
There's one in the chat on film, which
Okay.
I don't know the answer to. So.
Let me have a look. Directive 2011-77 EU. Let me get back to you on that, Matthias. Do you have an email address I can reach you at? Would you mind putting that into the chat? Okay, thanks, Matthias. I'll look at that and I'll respond to you. Any other questions?
Hi, Martin. Thanks for that. That's very interesting. I have a question, and I suppose it's more of a to get your opinion on the matter more than anything. But do you think controlled digital lending would ever be on the cards for libraries here in Ireland? So that's where I'm pretty sure you're familiar with it, but
Yeah.
that's where, yeah.
I mean, there's a lot happening in the background in relation to lending of ebooks and controlled digital lending. Obviously, at the moment, to allow controlled digital lending to happen in Ireland, the Section 70 of the Copyright and Related Rights Act would need to be either removed or reformed. So we dealt with that in one of the earlier slides, where it basically says that any copy that is made under the exemptions, so for preservation purposes, or for filling a hole in another collection, or for making available in a dedicated terminal, if that is subsequently lent, it immediately becomes an infringing copy. So the controlled digital lending is specifically precluded under Irish law at the moment. I know that people are looking at the question of whether legal deposit copies, which can be deposited in electronic format, whether the number of bodies that receive legal deposit copies might be extended to allow more libraries to receive them. Obviously, there's nothing within the Copyright and Related Rights Act to preclude the lending of legal deposit copies. But I think, that there is movement certainly within, as far as I understand it, within the Department of Enterprise, Trade and Employment, who have exclusive jurisdiction over copyright, to address the issue of the public lending right for ebooks. And I suppose if the response of publishers to addressing changes in the PLR, so in other words, changing the definition of book within the public lending regulations from a hard copy item to, a work, or using a definition from the CRRA, if that resulted in libraries being able to lend ebooks on a one copy, one user basis, the question then is, well, what if publishers just refuse to supply ebooks any longer? So what that will require is that there be some mechanism to allow libraries to lend if publishers refuse to supply. So in other words, if the PLR regulations are changed, PLR is payable on ebooks, then libraries will need either greater access to legal deposit copies, or Section 70 of the CRRA would need to be reformed to allow controlled digital lending. Does that answer your question? Sorry, I'm aware that was a bit
Yeah, no, it does. It's
long-winded.
obviously a very multifaceted issue. If it does come in, it has a knock-on effect everywhere else. So yeah, it's might not be the solve-all solution.
Yeah, I mean, like the Library Association of Ireland, you probably know, they have the ebook SOS task force, who are actively kind of working on this issue. And I know that the Department of Community Rural Affairs, sorry, DRCGD, and DFERIS, the Higher Education Department, are also actively concerned and interested in the question of ebook lending, because it is causing a massive problem for libraries, both in terms of throttling supply to the ebooks and just the costs and licensing terms that are applied. So my I suppose what I'd say is watch this space. I would anticipate within the next sort of 12 months that we may see some changes. You know, the other interesting thing just on this point of ebooks is that obviously all school books are now published exclusively by the state. So the state makes monies available to schools who then tender for the purchase of books, and they can purchase ebooks within that. But there's under the European accessibility regulations, so which were transposed into Irish law, so from June 2026, there's a requirement, and this is one of the few bits of statute in Irish law which actually references ebooks, but it states that ebooks and ebook services must be basically accessible to users who require, for instance, that documents be read to them, or they might require larger text. So, you know, people with I suppose, visual or learning difficulties must be allowed copies of ebooks which do not contain any technical protection measures. So I know that this is something that the Department of Education is actively looking into as to whether this will be something that will be built into the kind of the procurement regulations for the purchasing of school books. So again, that's the kind of thing that might have a knock-on effect in relation to how people view ebooks. Because at the moment, as I said, it's very much the view is that of the publishers that they are an entirely different entity. But I suppose my argument would be, you know, an ebook is much like an album. You know, you purchase an album by an artist. If you have it on a cassette, vinyl, you listen to it on Spotify, it's the work is the same, right? The only thing that differs is the format under which it's delivered. So my view is that, you know, ebooks are a book is a book is a book.
Thanks. Yeah, that's a great analogy about the different formats of music versus the ebooks and books.
Yeah.
Thanks, Martin.
All right. Thanks, Jesse. Samantha, you have your hand up. Do you want to go ahead?
Thank you. Yeah, just a couple of things. One, to answer a couple of questions you asked earlier on. For those of you who don't know me, I run the Irish Copyright Licensing Agency, which is the collective management organisation for the text and image sector. The COVID extension you referred to, where we doubled the amount, that ended in 2022. That was a permission given to us by our mandating publishers that we could do so for the duration of what was seen as an emergency at the time. The current education licence is based on the new statutory instrument from 2020, and we're doing a webinar for CONAL next week on how HEIs can get the best use out of their licence. Out of CommerceWorks, we are working with publishers at the moment to get clear definitions of what commercial availability should look like, and where the cutoff should be for out of print, etc. So we will be making that available, and we'll publicise that fairly shortly. Just a couple of things on public lending right. We distribute money on behalf of the British Library, in fact. So it's the Local Government Management Association have responsibility for public lending right in Ireland under the regulations. They outsource the running of the scheme to the British Library, who run the UK scheme and the Irish scheme in parallel. And then we receive money from the British Library and pay it to Irish resident authors and publishers in respect to both schemes. We also collect and distribute for a number of other schemes. On school books, just to correct something you said, that the Department of Education doesn't publish school books, and it doesn't pay for them directly. They provide a fund every year. They provide a grant every year to schools, which schools must purchase resources using that grant, and that covers school books, but it's not a straight line. The European Accessibility Act, the majority of school books are already accessible in most formats. And this is something we're very aware of, as you may be aware. InDesign, which is the most used public tool here, is not fully accessible yet. So there are issues with InDesign. And just on using legal deposit for lending, the main problem you're going to find is public libraries don't get legal deposit copies, and
Yeah.
legal deposit is of Irish published works, which is only a small percentage of what the consumers actually want. So just to make
No,
those
that's right.
comments.
So I suppose just in relation to your points, what I did say was that the government funds centrally, and I did say
Yeah.
that the schools are then required to go to tender.
They
for-
do, but they also use the fund for a
Right.
much wider range of products. It's
Yeah.
not,
Um,
and some schools
but
buy more
also-
books than others.
Yeah, understood. And also just in relation to the European Accessibility Act, I mean, the way that that's addressed at the moment is that there's often a requirement for people looking for, I suppose, accessible versions of ebooks to provide, for instance, a doctor's note directly to the publisher, and the publisher will then provide a copy of the book. So I suppose it's debatable whether that actually meets the requirement. But I mean,
That was the scheme prior to the EEA coming into force.
Exactly. So what I'm saying is, because the EAA coming into force in June, I would anticipate that there may be some changes in relation to how books are provided, and that it may be built into, I suppose, that tendering process. Sorry, what was the second point you made there, Samantha?
Just legal deposit. It's not a broad enough
Yes. Yeah.
collection of material really to be a problem
as
solver.
I said, what it's well. As I said, in the event that PLR were to be changed and publishers were to refuse to allow electronic books to be made available to libraries on that basis. So obviously that it would require a change to the Copyright and Related Rights Act, much in the same way that controlled digital lending would require a change. What I was suggesting is that it's one of the possible mechanisms that the Department of Enterprise, Trade and Employment may look at in order to ensure that there is a supply of ebooks. But as I said, this is all very much up in the air. These are all just kind of potential avenues rather than anything being particularly set in stone. And thank you very much for clarifying.
Well, thank you. It's been a very interesting morning.
Percentages as well in relation to the ICLA licenses, and also for noting and clarifying the work that you're doing in relation to Article 8 of DSM. So it'd be great to see that when it's.
We'll have that as soon as we're in consultation with the publishers at the moment. So
Brilliant. Okay, thanks.
Thank you.
Thank you. Any other questions? Okay, well, if anybody does have any queries, I think on the last slide, my email address was there, so feel free to send me an email, or you can get in touch with me via LinkedIn if you think of something after the session. Please don't hesitate to get in touch with me. And Matthias, I will have a look at your questions there, and I will send you an email.
There is a question in the chat from what I can see.
Sorry, say again, Daphne.
There is a question in the chat from Matthias Smith.
Yes, so that was Matthias's second question. I just said to Matthias that I'll have a look at that and I'll send him an email.
Great. Thank you.
Okay, well, I think we're at time now, Daphne, are we?
Yes, of course. I don't know if there is any other remark or question or any input you would like to share before we close the session.
No, that's it. I suppose just thank you very much to everyone who's attended. Thank you for taking the time to attend. Thank you for your attention. And yeah, it was my pleasure to deliver this. And thanks to you, Daphne.
Thank you, all of you. Thank you for your valuable perspectives. As initially mentioned, the training has been recorded, so we will have it uploaded on the project's website for your information as well for future use. And please, if anything, if you would like to ask any question, you can, of course, email us, and we will be honored to provide you with the responses. Thank you very much. Have a nice day ahead.
Thank you. Goodbye.
Bye.